forces to put this document together. And they're saying, number one, Steele's conduct did not interfere or threaten the administration of justice in the quote, in that quote, Steele believed his client's rights were violated, but did nothing to interfere with the court. Okay. They also go on to say that the court had less problematic alternatives. In other words, come on, man, you got to do something other than throw me in jail for, in this case, it was going to be 10 weekends, total of 20 days. So come on, let's use a better alternative, even if you believe I did something wrong. Did he do anything wrong, Matt? And was the punishment appropriate?
Well, it's interesting, Michael. I had a chance to take a quick look at the brief, and one of the things that they say is that this isn't about whether or not the ex parte hearing was proper or not. This is about, did the judge act appropriately under these circumstances. But really, this is all about that ex parte hearing, because once Steele learns that there was an ex parte hearing, from whatever source he learns that, he then has a responsibility to his client to make the objections that he did, and his conduct was completely appropriate in the circumstances. Now, the judge says, I want to know who told you. But that really wasn't the issue at the outset. The issue was, did this judge do something which is patently improper to have an ex parte hearing? And did the defense take appropriate actions to protect the record and protect the rights of their client? So, I think this was, an abuse of discretion by the court to take the action that it did and, ultimately put the defense attorney who's doing his job, who's zealously representing his client, in jail for 20 weekends or whatever the case is. So I think that they have a great argument in terms of their position with the appellate court.
Yeah, and I think with the ultimate recusal kind of puts a little bit of a stamp of approval on the fact that what he did was wrong. So Katherine, this is so bizarre. It's like the judge is mad because Steele won't acknowledge who he learned about this meeting. Well, who cares? Matt said, really, that's not the issue. It's irrelevant. But it's like, whoopsie, Glanville, I got caught with my proverbial hand in the cookie jar here, and now I'm trying to punish you because you caught me. What, if any, proper remedy may have, kept the judge on the bench?
Well, first of all, what he did to Steele was that the order was a direct summary contempt, which is very critical here and a big issue in the brief, of course, because what that means is that it's a summary contempt order that, okay, very seldom it's used against anyone, especially the attorney for a client in that trial, because it's disfavored, it's very severe, and it takes the due process out from Steele. What usually happens is if Steele would have gotten notice of what the charges against him was, and that he would have been represented by his own counsel, and then there would be a separate hearing and procedure with a different judge, not Judge Glanville, who was part of the ex parte hearing that made him tantamount to being a witness for what was at issue at that time. So that's one of the big issues that Steele is talking about in his brief. I should not have been ordered for direct summary contempt. I should have been given due process and explained my side of it, but he wasn't. He was just given that order and had to serve 20 weekends in jail. And summary contempt is usually granted when there's an administration of justice that is going to be interfered by the action of Steele. But as we can see, Steele was actually put in jail that weekend, and then he was brought to court to still represent his client. So it seems counterintuitive in terms of having a direct summary contempt.
Yeah, and they were able to avoid most of that confinement by filing papers that they did on an emergency basis. So he's still fighting to get it ultimately resolved, even though they had a temporary resolution to it. Yeah, and the judge wouldn't buy the, hey, it's attorney-client privilege. even if I have the source, and then I'm not telling you, I have a good reason not to tell you. It's work product, it's attorney-client. The judge was caught, and he handled it poorly. Hey, he's not on the case anymore. What a surprise. Okay, we're going to take a break. We will come back to this case as it continues to unfold, but we are keeping an eye on the Tejas matter as well out of Las Vegas. The defendant is on the stand. We'll take a break, come back. They should get back at it soon, and we'll join. Stay where you are.